Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications. Exercise number 5 and 6 on the speed of 90 words per minute. Start. There is one feature which is fairly striking in this case is that the funeral of the deceased was solemnized without any information to the police, and it is for this reason there appears to be neither any inquest report nor even a post-mortem report of the deceased. This circumstance may mitigate against the husband, but there is nothing on record to indicate that the appellant was responsible for any such activity. The prosecution has not led any such evidence complaining about the disposal of the dead body in the aforesaid manner to establish an intent on the part of the appellant to either obliterate the evidence or otherwise destroy it. The ocular testimony of Ramkumar P.W.1 and Srimati Seema Devi P.W.2 is totally silent in this regard. In such circumstances, any presumption against the appellant under any of the illustrations of Section 114 of the Indian Evidence Act would be impossible, as there is complete lack of evidence on this score. The prosecution does not appear to have concentrated on this issue, which appears to be evident from the fact that the family members of the deceased, including her mother-in-law, had reconciled, which also stands reflected in their statements made before the court. Consequently, what we find is that in the entire evidence of the prosecution, no element of mens rea arose to implicate the appellant for having intentionally murdered the deceased. However, as indicated above, the factum of throwing the cloth soaked in kerosene causing injuries to the deceased is established from the dying declaration of the deceased. The status of the dying declaration has already been held unimpeachable by us, as it is corroborated by the testimony of Nayab Tahsildar P.W.6 Ravi Kumar and P.W.9 Dr. Dilip Kumar Roy. In such circumstances, we are of the opinion that the appellant had the knowledge, if not the intention, to the extent that her action is likely to cause death of the deceased in the ordinary course of things. The nature of the injuries and the background in which the same came to be suffered by the deceased on account of a clear overt act of the appellant convinces us to accept that the prosecution has established the offence, but only to the extent as defined in Part 1 of Section 304 IPC. The prosecution, in our opinion, to that extent has succeeded in travelling the distance through its evidence from must have been to must be in the present case, and the appellant had such knowledge so as to cause death when she committed the offence. There is, as recorded above, a complete lack of evidence beyond reasonable doubt about the intention of the appellant to commit murder of the first degree. Our conclusion to that extent is not an alternative opinion but the only possible view, and therefore we are unable to accept the view taken by the trial court. The state government is entitled and empowered to fix the age of consent. The state can make reasonable classification, but while making any classification, it must show that the classification has been made with the object of achieving a certain end. The classification must have a reasonable nexus with the object sought to be achieved. In this case, the justification given by the state is only that it does not want to punish those who consummate their marriage. The stand of the state is that, keeping in view the sanctity attached to the institution of marriage, it has decided to make a provision in the nature of exception 2 to section 375 IPC. This begs the question as to why in this exception the age has been fixed as 15 years and not 18 years. As pointed out earlier, a girl can legally consent only after she attains the age of 18 years. She can legally enter into marriage only after attaining the age of 18 years. When a girl gets married below the age of 18 years, the persons who contract such a marriage or abet in contracting such child marriage commit a criminal offence and are liable for punishment under the Act. In view of this position, there is no rationale for fixing the age at 15 years. This age has no nexus with the object sought to be achieved, namely, maintaining the sanctity of marriage, because by law such a marriage is not legal. It may be true that this marriage is voidable and not void ab initio, except in the state of Karnataka, but the fact remains that if the girl has got married before the age of 18 years, she has right to get her marriage annulled. Irrespective of the fact that the right of the girl child to get her marriage annulled, it is indisputable that a criminal offence has been committed, and other than the girl child, all other persons, including her husband and those persons who were involved in getting her married, are guilty of having committed a criminal act. In my opinion, when the state on the one hand has laid down that abetting child marriage is a criminal offence, it cannot, on the other hand, defend this classification of girls below 18 years on the ground of sanctity of marriage, because such classification has no nexus with the object sought to be achieved. Therefore, also exception to insofar as it relates to girls below 18 years is discriminatory and violative of Article 14 of the Constitution of India. There are many other offences where the husband is either specifically liable or may be one of the accused. The husband is not given the immunity in any other penal provision except in exception to Section 375 IPC. It does not stand to reason that only for the offence of rape the husband should be granted such an immunity, especially where the victim wife is aged below 18 years.